Okay. Well, very unexpected live. I pushed the wrong button. I realized that we are 30 minutes behind in the feed for the hearing of Lori Vallow Daybell Day 8 for jury instruction, and I intended to record, but I hit the live button by mistake out of habit from joining everyone. So I guess we're doing this one live. We will bring it up and get this started. We're a bit behind, so some of you may already know a bit about this already. But I'm very curious to see what happens today. I hope everybody's having a great day. If anyone is here, can you tell me if I'm too loud? If I can adjust? And please feel free to text in the chat if my balance versus the feed balance is way out of whack. I did not get a chance to test that yet. But I do realize this feed is a bit behind, but we're going to get to it. Oh, Lori's coming in. Since I didn't tell anybody I was going live, I really don't expect anybody to be here. Oh, hey, hi, Couch. How are you? The feed should be coming up there. Lori just came in. The feed should come up. It should be the judge's voice first, usually. We got tech issues. We don't call that. We don't have them yet.
All right. We're on the record in CR 2021-001704, State of Arizona versus Lori Daybell. The state is present, the defense is present, the jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As of this morning, I mean.
Well, do you anticipate that changing?
No.
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence. Let's just go through page by page. I think it's probably the easiest way to do it. On the cover page, I did correct, I had 2001 instead of 2021, and I corrected the case number. The first instruction at the top, page 2, duty of jury evidence to be considered and rulings of the court. These are standard instructions in Arizona. I'm assuming there's no objection to those from the state?
No objection.
From the defense?
On page 2?
Yes.
No objection.
All right. Then on page 3, I did remove the stipulations because I don't think there were any stipulations. So on page 3, direct and circumstantial evidence, production of witnesses and evidence, redacted exhibits, those are standard. Any objection to those from the state?
Your Honor, I did object to the production of witness and evidence. I
want to hear about that because that's a standard given when we have a situation where we've heard about people like JJ Tiley, Alex Cox, we've heard about Summer, we've heard about Detective Moffitt. None of those people were called at trial. So I think this instruction simply says that neither side is required to call, basically everyone that's mentioned in the evidence.
guess as long as the defendant is okay with it. Obviously, I've not seen that previously included in an instruction. My concern was the burden shifting potentially, saying that neither side is required. And that seems to imply or in opposition of the fact that the defendant need not present anyone anyways, ever. That's my concern with that instruction.
All right, before we talk about that one, let me hear from the defendant. Any objection to the direct and circumstantial evidence and then the redacted exhibits on that page?
No, those are fine.
Okay, what are your thoughts on the production of witnesses and evidence?
I tend to agree with the prosecutor, but
that it shouldn't be in there?
Correct.
Well, if the parties are stipulating that it's not in there, I'll remove it. Is that the case?
I believe so, Your Honor.
Yes, Your Honor.
All right, by the stipulation of the parties, I'll remove that instruction. I probably should have brought my hard copy because you guys are working off a hard copy on my computer. This is kind of maybe paginate different. So now my next ones are indictment is not evidence, self-represented defendant. Any objection to those from the state,
No, Your Honor.
from the defense?
No.
All right, then the comments are not evidence. The reason I highlighted that is it was to alert everyone that I did change the language in that a little bit because the defendant's self-represented. It mirrors what I did in the opening, what I read to the jury before opening statements, more or less, in changing it from the attorneys to the prosecutor and the defendant talk to you about the law and the evidence. Are there any objections to that instruction from the state,
Not as changed, no, Your Honor.
from the defendant?
No, it's good.
All right, then we have credibility of witnesses, and on my page 4 is testimony of law enforcement officers, but that might be on your page 5. Any objection to those two from the state?
No, Your Honor.
Defense?
No objection to the ones that are in there.
All right, then we have expert witness. Any objection to that from the state,
No, Your Honor.
from the defense?
Nope.
All right, based on the defendant's indication that she's not going to be presenting evidence, I would remove defendant's testimony. I would keep in defendant need not testify, and I would remove defendant witness prior conviction if that remains the case. So any objection to that from the state,
No, Your Honor.
from the defendant?
Nope, no objection.
All right.
Can we add in there something?
What's
Is this the
that?
time to ask to add something in there?
Go ahead.
The standard 19, the defendant statement voluntary.
Voluntariness of defendant's statements.
Mhm.
That probably should be in there. What's the state's position?
No objection.
I will add that. I'll add that right after defendant need not testify. Just making a note. All right, then we have jury not to consider penalty. Any objection to that from the state?
No.
Defense?
Nope.
All right, the state emailed this morning. I think the state wants the alternative presumption of innocence, burden of proof in the Rajis. Is that correct?
Correct, Your Honor.
You want to make a record on that?
Your Honor, the current version the court has in here discusses the various levels of the burden of proof for preponderance and clear and convincing, which are not relevant to this. Case law is very clear under Portillo that the court is only required to present the Portillo instruction, which is partially on the next page in my hard copy, which explains to the jury the burden of proof for a criminal case. I think that going through other levels of burdens of proof without understanding or being provided context for that is confusing to the jury, is not necessary, and Portillo does not require it. So we're requesting the court just provide what has been mandated, which is the Portillo instruction.
What's the defendant's position?
We agree. It's confusing.
Okay. So I think that's just the last two paragraphs, right?
Yeah, from the three standards through the preponderance and the clear and convincing. So it would still have, the presumption of innocence, and then it would go to the beyond a reasonable doubts portion.
Okay, I will, by stipulation of the parties, change that instruction. So it'll read, the law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. Then I delete until the last two paragraphs. So then it will read, the state has the burden of proving the defendant guilty beyond a reasonable doubt. The rest of that paragraph. And then the next paragraph, proof beyond a reasonable doubt is proof that leaves you firmly convinced. And that entire paragraph, is that the agreement?
Yes, Your Honor.
Yes.
Okay. So my pages are not going to be the same as yours at this point. So we'll just go through it a couple at a time. Evidence of any kind, voluntary act, and then absence of other participant. Any objection to those three from the state?
Yes, Your Honor. And the evidence of any kind, I had sent in my email that we should remove acting with the advice of an attorney. Defendant is her own attorney, so she is. I think it should just be a period after evidence is left to the defendant, period.
You're right. I will remove that sentence. So what I would propose is it would read as follows. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. Is that what the state requests?
I would have left the decision on whether to produce any evidence is left to the defendant, period. And then the next sentence, cutting out acting with the advice of an attorney, and then have the last complete sentence as well.
I don't have a problem with that. What's the defendant's position?
I agree.
You agree with this state's
Yeah, I would
wording?
agree with, yes, just to cut that part of the sentence off.
Okay. I already deleted it, so read it back to me, state, please.
Sure. So the state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant, period. Then the defendant's decision not to produce any evidence is not evidence of guilt.
Judge is a fast typer.
The decision on whether to produce any evidence is left to the defendant. Okay, when we're done, we're going to print out another copy and make sure everyone's on the same page. All right, let me turn to the defendant. We've addressed evidence of any kind. Any objection to voluntary act and absence of other participants?
No objection.
All right, then we have motive. Any objection to that from the state?
We did have flight or concealment in the ones that we
I'm
have.
sorry, you're right. I should have stated, I did delete flight or concealment. I don't think it's applicable in this particular set of circumstances. So then we just have motive.
No objection to motive, Your Honor.
And from the defendant?
Yeah, no objection to motive. No objection.
All right, here's where mine's going to change a little bit. I did the charged offense, each instance where it says first degree murder, where it used the numerical first, I changed to a capital spelled out the word first in that, and then in the definition of first degree premeditated murder. And the reason I highlighted in here, there's a couple highlights, a person, and under premeditation, she or a co-conspirator. Those are changes I made to the standard because the standard just says defendant. So let's just talk about the charged offense, the definition of conspiracy, I'm sorry, the definition of first degree premeditated murder, and then the definition of premeditation. Any objection to those with the changes that I've stated from the state?
No, Your Honor.
From the defendant?
No, no objection to that.
All right, then where it's altered a little bit, so there was an accomplice based on liability, I'm sorry, based on the result of the crime that I had here. I've deleted that and instead put accomplice, the traditional definition of accomplice, in the definitions section. And I think what I'm going to have to do is we're going to print out a fresh copy and give it to you guys when we get there. And what I've inserted here is elements of a conspiracy, scope of proof of conspiracy, proof of membership in conspiracy, which in my original draft only had the scope, I think, of proof of conspiracy in a different spot.
Correct.
But does the defendant need those printed out to review? Because I have
I
changed
was going to
it.
ask for those to be added, so I did
Okay.
review them with my advisory council.
All right, I want to make sure, though, that you are literally on the same page with what's going to be read.
Yeah,
So,
I would like them to be printed so I can see them.
all right. We'll come back to that when we get you a hard copy. What I wanted to ask the parties was I initially included the Raji 4.04 for self-defense justification. But in a second look this morning, I think 4.05, which is justification, self-defense, physical force, and it specifically talks more about threatening or using deadly physical force, I think is more applicable. So what's the state's position on that, inserting 4.05 in place of 4.04?
I would agree, Your Honor. This relies mostly on physical force. Obviously, we're discussing deadly physical force here. So otherwise, the jury has to try to implant deadly physical force throughout this entire instruction.
And I think they should both be in, but
Well, while we're on the subject, are you requesting any other justification instructions?
well, I was going to ask for that for 2.04A,
For what?
the 2.04A, 2.0401A.
What's that? I don't have them all memorized.
Oh, the Arizona 13204.
Is that a Raji you're referencing or a,
Yes.
hold on, let me bring them up. What's it called?
It's the Cashion. Is that what that is?
So,
I was on the wrong one. So we are going to be asking for those, but
I don't think I'm clear on what you're asking for.
so we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of, or crime prevention,
Correct.
in addition to justification, deadly physical force.
Correct.
All right, those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises,
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing
correct,
on the
rather than
property.
being invited into the home. So I don't see that justification in defense of premises is appropriate, given the facts that we have here.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
There's no evidence of that specifically, but I guess it could be inferred, and that I would hate to risk a reversal on something like that. So let me take a closer look at it.
I think the other question is on that goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises, which we have admitted evidence of.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease. That would seem to have some apparent authority to be there, but let me take a look at it.
It refers to criminal trespass, which I think the point here is you cannot be criminally trespassed off of your own property.
So I will give the 406, which is justification for defense of a third person. I'm not going to give justification in defense of premises. It requires that there be a criminal trespass. I think it's confusing to the jury also if there's an argument that's made that he committed a criminal trespass because he was on the lease, he had authority to be there, and he was, even if he didn't have authority to be there, he was invited in to get his son.
In lieu of that, Your Honor, then we would ask to add 418, 4.19, defense of residential structure.
Mhm. We hear her whispers again. I can't make out what she's saying, though, this time.
Record on 4.11, which is use of force in crime prevention.
Sorry, I was looking at 418 that defense just raised. Let me go back to 411.
Hmm. I think this is the only thing they had to cover today was jury instructions. I don't believe there's any outstanding motions. He outright denied her motion to dismiss for Rule 20 yesterday, which, by the way, is standard. Almost every defense attorney opens their case
Trying
with
to find
that.
411, but my
So,
search is
uh,
not.
I'm going to hop back to 418. 418 is not applicable. 418 applies to home invasion type situations, and it talks about threatening or using deadly physical force. If the person against whom the physical force is threatened or used is in the process of unlawfully or forcefully entering or having unlawfully or forcefully entered a residential structure or occupied vehicle. So there's no indication that Charles forcefully entered the house.
He was picking up JJ and he's on the lease.
I'm
It
not
doesn't
inclined to
apply.
give 418. Does the
To
defense want to be
mislead
heard
the
further on
jury.
that?
No, Your Honor.
And then was there another, you said after 418?
I just said 418 and 419. I guess that's the presumption of that.
Or, so 419, that's applied to the residential structure, so that one wouldn't be applicable if 418 is not applicable.
Okay.
So I'm not going to give 419. Did the state look at 411 yet?
Just found it, sorry.
I agree, Rocket Couch. It might have been standard, but it sure was funny yesterday. It was read out. I mean, it was obviously prepared ahead of time. What was really great is Treena K was ready. She had a prepared statement about how the evidence is enough. Do you think she's disappointed Lori's not testifying? I think Treena K was ready for her. I do. I think she may have even been looking forward to it a little bit.
Your Honor, I think probably given Carson and the allegations that the victim used a bat, we would have to give that as well as then the instruction for the crime that they are indicating they believe Charles was committing, as is required per the
So you agree that 411 needs to be given? So that's my reading as well. So I will give 411, just so we're clear, I'm removing 404 self-defense justification. I'm adding in 405 self-defense justification, deadly physical force. I'm going to add in 406 defense of a third person. I'm going to add in 411 crime prevention. Okay, I think that brings us to the definitions. I removed deadly weapon. I think I had it in there initially because I thought it was in the justification statute, but closer read, it's not. So in the definitions that I have right now, I have intentionally with the intent to, and then intent may be inferred. Then I have knowingly, willfully, knew. And if the state is required to prove the defendant acted knowingly, that requirement is satisfied if the state proved the defendant acted intentionally. Then the next paragraph, a defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense, and the rest of that paragraph. Any objection to those from the state,
No, Your Honor.
from the defense?
No, Your Honor.
And then here is where I've inserted the traditional definition of accomplice, because I deleted the completed act definition of accomplice. So this says accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following: 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Any objection to that from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Then I have a few more definitions: act, conduct, physical force, and a definition of deadly physical force. Any objection to those from the state?
You said something else I don't see in here, so sorry. Oh,
Act.
act was a previous page, sorry.
I kind of did it in alphabetical order. So accomplice went in, then act. So act, conduct, physical force, deadly physical force.
No objection.
From the defense?
No objection.
While we're in the definition section, I'm going to have to look at when we're adding crime prevention and defense of a third party, whether there's any additional language in there that would require additional definitions. But other than that, are there any other definitions the state's requesting that I didn't include?
Other than, obviously, the state hasn't looked at either of those, either new instructions requested by the defense to see if there's additional information. So I would have to look at that prior to approving these.
Okay. But other than that, you don't have any that come to mind?
Not off the top of my head, Your Honor.
All right. How about from the defendant?
No, Your Honor.
So then the rest of this is pretty standard. It's the jury foreperson and the closing instruction, and then I have a form of verdict. Any corrections, objections to any of those from the state?
Just the form of verdict, changing that one ST as well to first degree.
Okay. There's no, we don't need any interrogatory on dangerous. It's automatic, right?
It would not be automatic.
It's
I don't
not.
believe so, because it does not require the use of a weapon. So we would actually need to have a penalty phase to
Okay,
have that
so that-
determination.
That would be done in the second phase, if there's a second phase.
Correct.
Okay. Let me turn to the defense. Those last, first of all, any other definitions that you think need to be included that I didn't include?
Hold on one second. Your Honor, we had missed one that we wanted added, was mistake of fact, 205. I'm sorry, I didn't want to backtrack.
Oops.
Mhm.
The revised jury instructions from 2 years ago don't have a 205.
Sorry, it's 204. I apologize.
Causation, ignorance of fact, is that what you're talking about?
Correct.
2.0401A Ignorance or a mistaken belief as to a matter of fact does not relieve a person of criminal liability unless, one, the ignorance or a mistaken belief as to a matter of fact negates the culpable mental state required for a commission of the offense, or two, the ignorance or a mistaken belief as to the matter of fact establishes a defense of justification. So what's the mistake of fact that you think exists?
This is. I'm wondering how that you can change that one, actually. She seems a bit flustered today to me.
Your Honor, it's mostly the mistaken of fact that have been presented as evidence in this case, like one shot versus two shot, you were being attacked, you weren't being attacked. It's things that the state is proposing that I'm denying.
Well, you can deny those and you can argue that, but that's not really what is meant by a mistake of fact. It refers to a misunderstanding of the facts that would somehow negate any criminal liability. In other words, you'd have to be under a false belief about a fact. I think an example might be if someone's breaking into your home or someone's coming into your home, you thought it was a burglar and you shoot them and it turns out to be your spouse. That might be a mistake of fact. So a dispute as to what the facts are, what the facts mean, wouldn't warrant this instruction unless you have something else.
That was all. That was what I was thinking.
Okay. What I think I'm going to do is I have to go back to my office in the central courthouse. I have to edit this a little bit. I'll add in those instructions. If you guys can wait here, we'll get you a clean copy by noon. Review that copy over the weekend, make sure there's no other additions, corrections, or mistakes. And then the procedure will be on Monday when the jury comes in. I'm going to ask if the defendant's ready to proceed, and I'm assuming you're going to say that the defense rests. And when that happens, we'll hand out the final instructions, and I'll read the final instructions, and we'll go right into the closing arguments.
Your Honor, then I'd asked defense previously, there are officers who are under subpoena still, that they be released at this point?
That's fine, Your Honor.
All right. And well, anyone at this point can be released from your subpoenas, is that correct?
That's correct.
Okay. I'm just trying to decide the best start time. I'm thinking read the instructions at about 11, break for lunch, and go into the openings early at 1, or you can start and have it broken up by lunch.
I would prefer the court's option of reading the instructions, going for an early lunch, and then not having my
All right.
closing.
I'll have my staff contact the jury and tell them to report at 11. And then we'll still meet here at 10:30, make sure everything's good on the instructions and the defendant's intentions to rest. And then I'll read the instructions before lunch. That may mean we break a few minutes early for lunch, but we'll have them come back at 1 and go into the closing arguments. All right, while we're here, I'm going to call the other case as well, CR 2022-001242. And the state is here, the defendant's here. I'm going to go ahead and set the official trial date to begin May 30th at 9:30 a.m. Actually, 10 a.m., May 30th at 10 a.m.
Your Honor, are we still meeting though the 29th to do strikes?
Yes, I'm going to get to that. I will set a final trial management conference to discuss the remote questionnaire and confirm we're all good to go for the second trial. For May 14 at 10 a.m.
And Your Honor, I will say okay for now. Obviously, we don't have the victim here and we didn't notify him of this hearing. So if that does not work for him, then I will ask to move that.
All right, for now, we're setting the final trial management conference, May 14 at 10 a.m. At that time, we'll discuss modifications, if any, to the previous questionnaire. We'll discuss the exact timing of that questionnaire going out, but it'll go out probably May 21st and end sometime on May 26th or 27th, because the 26th is a holiday. And then we will meet on May 29th to go over those responses that the remote questionnaire produces. I'm going to set that for 1 p.m. on May 29th.
Your Honor, I received a notice from the state this morning, actually, about notice of 404B information for that trial. So are we going to set a 404B hearing for that as well? Would that be at the same time, or do you want to do that at a different time?
Let's discuss that on the 14th.
Okay.
I did see that come in as well a couple days ago. So the anticipated schedule for trial, let me confirm with the state. You think the second trial is similar in length to this trial?
I believe so.
So my proposed trial schedule that we talked about is going to be June 2nd, Monday through Friday, June 6th. We'll shore up those hours and where we're going to be physically located, because I don't know if we're going to be in the same courtroom or not. But tentative schedule, June 2nd through 6th, Monday through Friday, June 9th through 13th. Depending on how far we get, I may cancel that Friday the 13th, but I'll let you know at the start of the 9th or the 10th. And then I have to be dark the 16th through the 20th. And if we need June 23rd through 25th, I think that should be enough time. So that's what I'm going to screen through is those dates for the remote questionnaire.
Not the next June, you said June 23rd through the 26th, but not the 30th through the 3rd?
Yeah, and here's why I'm thinking that is you completed the state's case in this case in
It'll be
7 trial days, 7.5 trial days, 8 trial days. And the 2nd through the 12th is already going to be 9 trial days. And then if something goes wrong, we still have the 23rd, 24th, and 25th. So that's going to be 12 trial days. And some of those trial days I can make longer depending on everyone's schedule. We might be able to start earlier.
All right, the state will ask that we screen them through July 3rd. I just think there is always things that happen, and I would much rather have a jury prepared to stay longer and have them end late than have a jury angry at us because we told them that they would be done on the 25th and something happens and they are not done on that date, or they're deliberating later. So I would ask they be screened through July 3rd.
That would give us over twice as many trial days as we had in this trial.
We had screened these through the 15th, I thought, of June. So
What's that?
didn't we screen these jurors through the 15th of June? So,
No, May.
May.
I'm sorry, of May. So we had,
We screened for 6 weeks and we did it in 2.
I understand, but I guess I don't see that as twice as long as this screening.
We had 21 trial days scheduled in this first trial, and you did it in 7.
We had 28 days scheduled in the other one. In any case, that's all I'm asking, Your Honor. You can do as you wish. That's my proposal, just. and
We can
that-
confirm it on the May 14th when we meet at the FTMC. I'm open to it. My hesitation is if we go all the way into the 3rd, I think we're going to run into losing a bunch of jurors who are going to go out of town for 4th of July, and they might be leaving on the 2nd or the 3rd. And I think we're going to lose a lot of jurors just based on that holiday where people go out of town. With that said, the current last day is May 11 on that trial. So as defendant, want to make a record because I am going to exclude time. I know you object to
I
the
do
exclusion of
object to it.
time.
I object to not having it by May 11th. Correct.
You want to,
What?
do you have anything further than that?
No, just that, yes, that I would like to have my speedy trial by May 11th.
All right. Well, we screened the first trial through May 15th. We can't do, you can't do, and the state can't do, and I can't do 2 trials at the same time. Additionally, the state indicated they need to make arrangements for out-of-state witnesses to come well in advance of the trial. There's scheduling issues for myself. I'm out part of the week of May 19th. I'm out and coming back early the week of May 26th to do jury selection. Additionally, I guess the delay is of minimal prejudice given the current sentences that you're serving. For all those reasons, the court will exclude time
Ooh.
from May 11th. The new last day will be June 30th. All right, let me get these jury instructions, an up-to-date draft for everyone. Please stick around. I'll have my staff drop that off hopefully in the next 15 to 20 minutes. And then again, when you review those over the weekend, please alert staff through your advisory counsel or your paralegal if there's an issue, because we're gonna have those all printed out Monday morning if we don't hear from anyone by about 10 a.m. Again, we'll ask my staff to contact the jurors and have the jurors report for 11 a.m. on Monday.
And Judge, is the court able to just email those to me, or do you want me to stay here and wait to
I
get a
could-
hard copy?
I will email them to you and advisory counsel and the paralegal, but if you want, you want a
I'll
copy
wait for a hard copy.
yeah, I'll print out a hard copy for the defendant to take with her here today.
Thank you. Thank you, Your Honor.
All right. Are you signed up for that?
Okay.
All
I
right.
think that's it for the day. And wow. Okay. I still have it on down there in case anything happens, but I think that was it. Wow. This was a surprise live. I'm glad that you guys joined me. The first thing that they asked coming in, the first thing that the judge asked is if Lori had changed her mind overnight, and currently she has not. She is not going to be presenting a defense. She's not taking the stand. But when asked if that's the way it was going to stay, she kind of hedged a bit. And those of you here heard that, if you go back, which was quite interesting. I don't know. Does she think she can pull like a surprise? Like Monday, oh, I've had time to think about it and I've decided I'm taking the stand. That does affect the jury questions and it will delay things a little bit. And I know the judge won't be happy, but from what I've researched, they can't stop her. She has to declare to the jury that she rests the case. And if she doesn't, she doesn't. They try to do as much as they can ahead of time. But as you heard in the jury instructions, it will change them a little bit. Not very much. It would not take much to finish the jury instructions up. But I think if she does that, we will hear her testimony, and then they would do the jury instructions after that. And to get them all typed up and distributed, then they would probably start the next day with closing arguments, because the jury instructions have to be done. It would just delay it a day. It would make it messy for Karen Reed's trial, but for all of us. But what are you going to do? It's in my intention to be live Monday with this, of course, closing arguments, and also my intention to be live on Tuesday for opening statements in Karen Reed. So on that, I think I'm going to end it. If you guys don't have any questions, let me just go through the chat really quick. Liam says she's a tease. She did. It did come off that way. Of course, it did come off that way, that she was just teasing. So yeah, I don't know. I don't think this trial went the way she thought. There was a question in there. Do you think that she will bring a defense and take the stand for the second trial? This is a much lighter trial. It's only conspiracy for attempted murder. There's a lot of the same conspiracy type evidence that they've got to bring together. But again, Alex Cox, the main person who they think fired the weapon at Brandon Bordeaux, is not available due to his demise. Chad Daybell is in Idaho in maximum security on death row. And Lori's still there. They've got the footage of the preparation. They also have other text messages more damning about that incident that we didn't hear in today's trial that have been floated around that I do believe will be admitted and presented. But as far as physical evidence, there's the video. And then, of course, it's going to be the tracking of the cell phones again in the vehicle. And that's about it. I know Treena K said it would take about the same amount of time, but I really don't see it. But then again, I don't know all the evidence that she's going to be putting forward. I think she's just being cautious, asking for the extra time because, like she said, she doesn't want to give the jury the wrong impression that they'd be out of there quick and then have to hold them over. And also, I noticed the judge didn't even add anything about calculation on Lori's on the defense side. He never even said, like, how long do you expect to present your case? I didn't hear that. Did I miss it? I didn't hear him. He just kind of went right over it. I'm sure they're allowing for time, but I don't think he thinks that she'll be, if she's not putting a defense on here, that she'll put a defense on there. But no, we know Lori a little differently, don't we all? We know she's going to sit there and stew about all she didn't get to say. And also, the 404B is evidence of past stuff, past incidences that come in that go towards motive or credibility. And I wonder which ones they're going to be trying to get in. We'll hear that in the hearings in May for the second trial. Yeah. Yeah, Liam, it is frustrating, but that's the law here. And I honor and respect it, even the worst cases to where we think atrocities have been done and they are guilty, guilty, guilty. This is our system. This is how we do it. And, this is the system I love. I have great respect for it, and I love to see it in action. It does seem unfair sometimes, especially when you know someone's guilty. They're practically shoving it in your face and they get off on a technicality or something of that nature. So something happens, mistakes get made. it's the system we have to try to keep things fairly, and hopefully they just keep culling it, keep trying to improve it, or keep changing it just slightly here and there. But the foundation of all of it is everyone is presumed innocent until a jury of their peers says otherwise. So that's the way it goes. Oh, I know you don't disagree. I'm just like, I agree with you that it's very unfortunate that we see others not getting the process based on the country's view of their rights, the administration's review of their rights. I understand. I understand what you mean. And I'm with you on that. It's frustrating to see. Well, all right, on that, I'm gonna end it. My surprise live. Thank you for joining me. I will see you all on the weekend, Saturday, around the same time for part 3 of the 50th Law, and Sunday for a hang. If anybody would like to join me, please hit me up. It's open for everyone. It's casual and it's nothing. Nothing planned. We make no promises, except for that we'll hit the like button. So on that, everybody enjoy your day.